Domestic violence is a serious issue. It's no laughing matter, and certainly prosecutors take these cases very seriously. For years, women, men in abusive relationships have had their voices swept under the rug. They haven't been treated fairly, they've been ignored, they've been told he or she will never do it again. But what we have learned, especially in California, since especially in the 1990s, the O.J. Simpson case, and everything that's come after, is that domestic violence victims, the real victims out there, need to be heard, they need to be protected, and these cases are going to continue to be prosecuted at the strictest levels, especially in California, especially in San Diego. In this video, we're going to break down the different types of domestic violence offenses we see, from serious felonies all the way to the most basic domestic violence misdemeanors. We're going to talk about what some of the elements of those offenses are, what the prosecution needs to prove, what some defenses may be, and how you best protect your freedom and your future if you or a loved one are facing these serious charges. My name is David P. Shapiro. I'm a San Diego criminal defense attorney since 2007. Me and my firm have handled hundreds of domestic violence cases at the highest of levels, particularly here in San Diego. First step in understanding a domestic violence offense in California is really to differentiate it between any other type of offense. And the first thing that's required for a domestic violence charge is the existence of a domestic relationship. Now, a lot of people get, bent out of shape about, hey, we're not even dating anymore. I don't live with that person. How could it be domestic violence? Well, that's not what the law says. It could be a cohabitating relationship. It could be a former romantic relationship. You don't have to necessarily have a child with the accuser in order for it to fall under the umbrella of what we see a lot of times as defined in Penal Code Section 1203.097 and certain family code sections as well. So there's really two very common domestic violence or domestic battery offenses. The more serious one is Penal Code Section 273.5. The less serious of the two is Penal Code Section 243E1. Both are domestic violence offenses. Both come with certain mandatory conditions of probation or sentence, depending on what that sentence is, and both need to be taken very seriously. Now, the most serious of the two domestic violence offenses is Penal Code Section 273.5. That can be filed as a misdemeanor or as a felony. If filed as a felony, if convicted, a person convicted of this offense could face up to 4 years in state prison. Doesn't necessarily mean they need to or that they will, it's just what the law prescribes. Now, if great bodily injury is inflicted, it could add an additional 3 years, potentially an additional 5 years, potentially more time, depending on the extent of the injury alleged. Now, 273.5 of the Penal Code talks about a corporal injury to a spouse or someone with an existing romantic or dating or cohabitating relationship. So there's a couple of things there. Like any domestic violence offense, it needs to be proven that there was the existence of this relationship that qualifies under the law at some time. And there also needs to be an allegation that a traumatic condition or corporal injury or potential for corporal injury was in fact created. So a lot of times people will come into our office and they'll say, well, how can I be charged with felony domestic violence if my accuser doesn't really have a mark on them? Well, that's not what the law requires, right? Now, if they are seriously injured, then it could be felony domestic violence 273.5 and one of those enhancements to the sentence as a result of that injury. But a straight 273.5, whether as a misdemeanor or as a felony, just needs to really be a situation where a traumatic condition is present and that you as the accused are the result of it. So a really intense domestic violence situation that could have turned physical or turned really chaotic could be charged with that offense. Now, just because you're charged, or more importantly, just because you might have been arrested for a Penal Code Section 273.5 offense doesn't even mean the prosecutor will file charges against you. Sometimes you could be booked on a felony charge and be like, oh my God, this is a $50,000 or $100,000 bail situation, and a prosecutor doesn't file charges at all because they understand that there are many defenses, many viable defenses to domestic violence charges, particularly to the 273.5 of the Penal Code section. Penal Code Section 243E1 is the most basic domestic violence statute in the state of California. What is required is pretty simple. A battery, and the person who's on the other end of that battery has to qualify as a domestic partner, a spouse, a former relationship, those types of things to make it a domestic battery. Under Penal Code Section 242, an unwanted touching, no matter how slight or no matter how serious, could qualify. Under 243E1, you have that touching alleged and you have the existence of that relationship. Now, unlike a Penal Code Section 273.5 domestic violence charge, a 243E1 charge has to be filed as a misdemeanor. It cannot wobble up or down from a felony or a misdemeanor, so it's certainly the less serious of the two domestic violence offenses that we usually see. What's normally present there is an unwanted touching. It doesn't necessarily need to lead to a significant or a serious injury or a traumatic or corporal injury to a spouse, those types of big words that we hear under a 273.5. It's a basic battery with someone involved in a domestic relationship. But what's important to know is that a lot of the mandatory conditions of a sentence, a lot of the mandatory conditions of a probation sentence, even if you're like, hey, I avoided jail altogether, even under a 243E1, there are still a lot of those conditions present, like 52 weeks of domestic violence program, like the ban on firearms for a significant period of time, if not indefinitely, that means for the rest of your life with that domestic violence offense. There's also things like a stay away order, criminal protective order, just like you would see in a 273.5 offense, even as a misdemeanor, certainly as a felony. So whereas the 243E1 is a lot less serious than a 273.5 in California, there are a lot of similarities. Now, domestic violence offenses are not just limited in California to Penal Code Section 273.5 or Penal Code Section 243E1. Oftentimes, they are paired with things like criminal threats under Penal Code Section 422, dissuading a witness from testifying under Penal Code Section 136, or false imprisonment under Penal Code Section 236 or /236, 237. It's not just as simple as a domestic battery. These allegations usually come hand in hand. Now, the first of these offenses that are not necessarily unique to domestic violence, but often we see paired with domestic violence offenses, are criminal threats under Penal Code Section 422. Now, they can be charged as a felony or as a misdemeanor. In addition to the punishment, just the nature of it being a felony, it could be punishable by up to 3 years in state prison. A big difference between whether the case is charged as a felony, certainly if it resolves as a felony, or as a misdemeanor, is the fact that criminal threats as a felony is a serious felony in California. What that means is it is a strike. So imagine the difference between a felony criminal threats and a misdemeanor being the difference between having a strike felony on your record and or a misdemeanor. Very important difference. One example we see a lot of a criminal threat, particularly in a domestic violence context, is a husband and wife may be arguing and one party says to another, I'm going to kill you. Doesn't necessarily need to be during the course of the alleged abuse. Criminal threats could also be in writing. They could be submitted electronically. Sometimes they could even be communicated through a third party. But the important thing is it actually needs to be a threat of great bodily injury or death. And what's really important to understand when accused of a criminal threat is a lot of times people will, get questioned by the police, or their accuser will say, hey, why'd you say that to me? Or why'd you say that to this person? And you think you're doing yourself a favor and say, well, I wasn't going to act on it. Well, that doesn't really matter as much as how that other person perceived it or how a reasonable person would perceive it under those circumstances. So a criminal threat doesn't need to be paired with domestic violence, but it certainly doesn't help in the context of domestic violence, because that's when we start seeing these offenses being charged as felonies, and these are strike felonies if you're ultimately convicted of a criminal threat under Penal Code Section 422. Now, one offense that's often paired with domestic violence offenses that every time I think of this offense, I think of one case in particular, is Penal Code Section 136, dissuading a witness from reporting a crime or from potentially testifying. In the context of domestic violence, we see it a lot where, let's say, husband accuses wife of domestic violence. Wife gets arrested. During the course of the case, the wife communicates through husband, whether directly or through a third party, hey, tell the prosecutor that this never happened, or tell the prosecutor that you don't want to show up at court. In the context of a domestic violence, dissuading a witness from testifying or reporting a crime is taken extremely serious. As a felony, it is a strike felony. And the worst thing that we see a lot of times are situations involving misdemeanor allegations of domestic violence, but then our client gets rung up on a felony dissuading a witness from testifying. Let's explore how that happens. Well, one case that stands out to my career was a domestic violence case we had that involved brandishing a firearm and relatively low-end, thankfully, domestic violence allegations. While the client gets arrested, he's facing misdemeanor domestic violence and brandishing of firearm charges under Penal Code Section 417. But after his arraignment, he gets taken into custody. A judge, hearing the evidence, increases bail, client gets remanded into custody. Now, we're not on the case just yet, but while the client is in custody, he is making calls to a family member. And he is literally going down the line, step 1, step 2, step 3. And guess what's happening to those calls? Those calls were recorded. We were able to avoid convictions on the brandishing and domestic violence offenses, but guess what happened? The client got convicted on the dissuading a witness from testifying or reporting a crime charges based on what they said while they were in jail. Lastly, let's look into false imprisonment under Penal Code Section 236, or sometimes we see it as Penal Code Section 236/237. False imprisonment could be accomplished by means of force or threat, or sometimes not at all. And that's an important distinction whether or not you could expect to be charged with as a felony or as a misdemeanor. Now, false imprisonment in a domestic violence context usually plays out as follows. There's an argument. One party tries to leave to try and defuse the situation, and the other party prevents their ability to leave. They stand in their way. They take their car keys. They throw their car keys out the window. We've seen it all. And basically, you're preventing someone from their ability to move freely throughout their house, throughout their car, in society in general. Now, sometimes people may get caught up if they're being investigated or they get contacted by a detective and they think they're doing themselves a favor. It's like, no, I didn't put my hands on her. I didn't put my hands on him. But what I did do is, I just stood in front of the doorway and made sure that, they weren't going to get by me, right? You think you're doing yourself a favor. You think you're talking yourself out of domestic violence offense. And what you just did, you just talked yourself into a false imprisonment offense, right? So it is essential to understand what your rights are, what the law is. Certainly, if you're going to try and talk yourself out of it, which is never advisable, the best approach, keep your mouth closed. Now, one of the more serious offenses that we see in the context of a domestic relationship is Penal Code Section 261A2, and that is rape by force or threat. Now, how do we see that in a domestic relationship? Well, there's this old school age of thought here that, you can't rape a spouse, you can't rape a girlfriend. It's a consenting relationship. Well, that's not the case. Okay, I hate to break it to you, that's not the case. And what we see in a domestic relationship is a lot of times women or men will say, hey, I only had sex with that person because if I didn't, I was gonna get hit. I was gonna get harmed. Well, that is rape the same way as forcible rape is defined under Penal Code Section 261. In fact, 261A2 is where a prosecutor will charge you a lot of times if your loved one, a spouse, a girlfriend, a boyfriend, whatever, makes accusations that they did not knowingly or voluntarily consent to the sex act. And the basis of it is that they only consented out of force or fear. And that's often tied into domestic violence. Think about how quickly things could spiral just by the power of the accuser's word. Don't make things worse by throwing your word into the mix. So now let's talk about some consequences of a domestic violence offense. Now, for a lot of people out there, just being charged with a domestic violence offense will turn their world upside down. There may be a temporary protective order. They may need to move out of their house that they bought, their house that they pay rent at too. If convicted and you're fortunate enough to get probation, that requires a batterer's intervention program, a domestic violence recovery program, DVRP in San Diego. It's usually 52 weeks. Criminal protective order. With that criminal protective order, your inability to bear firearms. If you're convicted of domestic violence offenses, a lot of those domestic violence offenses, lifetime, ban on firearms. Can't possess a gun for the rest of your life. Not to mention what the public thinks about it. No one's gonna wanna work with you, no one's gonna wanna talk to you, especially if they have a pre-existing relationship with that other person. Your name, your reputation, your relationship with your children, all of which is at stake. If you're in the middle of a divorce and you get convicted, that will affect your ability to have child custody. Lifetime effects. If you're not a United States citizen, a domestic violence offense could wreak havoc on your ability to become a citizen. So whether you're charged with domestic violence as a misdemeanor or as a felony, you need to understand these consequences that will affect your life far beyond the courtroom, because these offenses stick with you forever. If you take one thing away from this video, let it be this. Domestic violence accusations are serious, but these cases can be won. First step is to keep your mouth closed when under investigation. Be careful of text messages, because a lot of times this will destroy otherwise strong defenses. And don't give up. These cases can be won. They are won with the right facts, the right lawyer, and the right set of circumstances, especially when things are handled early on the right way. You have a shot. So protect your freedom, protect your future, know your rights.